Star one? Was it 1 star or star one? Good morning and welcome to today's webinar. Could I will just take you through the presentation. So if we have a little technical tour to begin with. So you can see on your screen there's a little orange arrow and you can maximize or minimize the dashboard by clicking on that. And there's also a questions box which you can ask any questions in there, and we'll ask those in the Q&A session at the end. Before we go any further, can I just ask if you can type in the question box to say yes if you can hear us okay and if you can see the screen okay. Oh, lovely. Thank you very much. So our speakers today, we have our guest speaker here today, Priya Sejpal, a Senior Associate at Solomon, Taylor and Shaw Solicitors, and Jonas Salem from Business Development from the Sheriff's Office. Could I also ask you in the answer box just to type in how many of you are watching and taking part in this webinar at your office? We will ask you, we'll have an online survey at the end of the webinar. If you could give us your feedback on the survey, that would be very much appreciated. The webinar will count for 1 CPD point, and we will send the slides and a copy of recording and your CPD certificate to you by email this time tomorrow. Just as a little disclaimer here, please treat the contents of this webinar as food for thought, but don't take any action based on its contents unless you've taken legal advice. The speakers cannot accept responsibility for any errors or inaccuracies, loss or damage, unless we've given you personally specific advice relating to a matter about which you've given us full background details. You must also bear in mind that the contents of this webinar are based on English law, and because it contains archival material, that material is bound to go out of date. So the aims of today's webinar is to provide a sufficient understanding to landowners on how to recover commercial property, land or rental arrears, along with the options available and other considerations to take into account. I'd like to hand over to Jonas from the Sheriff's Office to tell us a little about the Sheriff's Office, and then to Priya about Solomon, Taylor and Shaw.
Hi there. So the Sheriff's Office, we are authorised High Court enforcement officers. We cover the entirety of England and Wales. Our authorised High Court enforcement officer, David Asker, is appointed by the Lord Chancellor. Now, the total experience that the Sheriff's Office has got is well over 75 years of experience. We've been operating for in excess of 30 years, and we've pretty much seen everything that there is to be seen. Whether these are from evicting sort of normal landlords or tenants, etc., or down to protester management, we've pretty much seen it all from our side. Priya?
Yep, and similarly, Solomon, Taylor and Shaw, we've seen it all as well, having been around for a little while as well. I must say that we are a specialist property firm. We do have other areas of work, but we are primarily involved in a lot of property work, which is contentious and non-contentious. So we'll be talking about a lot of the contentious stuff that goes on today, which we can definitely be on hand for. The firm we are very well known in the market. We are Legal 500 for 2020, and I do definitely say that our services are excellent. So any questions insofar as the law is concerned would definitely be suited to answer those questions for you.
Thank you. What we'll be covering in today's webinar are the options for the eviction of commercial tenants, so looking at forfeiture of lease and also eviction of tenants under a possession order. And then the second part of the webinar, we will cover CRAR, commercial rent arrears recovery, and any other methods of commercial rent recovery that might be appropriate. And we will end with a question and answer session. We will have 2 polls during the webinar, and I'd like to hand over now to Priya.
Okay. Well, the first thing is a lot of people want to know is what is forfeiture, and it does seem quite simple, but the slide does say it all. By the way, the slides have been drafted in a way that you could probably just take them, look at them, and read them and understand it all. But we are just happy that you're hanging out with us today, and we can talk you through what we think. So forfeiture is the right of a landlord to terminate a lease prematurely upon the default of the tenant. And I must say that when you hear the word forfeiture, it is often interchangeably used with the word re-entry. So if you hear that, then it's one of the same thing. So a lot of tenants can be evicted via two methods, and that is re-entry, which is going in to a property physically and peacefully. And the second method is obtaining a possession order through the court and then dealing with the High Court enforcement officers at a later stage. So there are two ways in which you can do it, and one must be very careful as to which option he or she chooses when looking to forfeit a lease. It's subject to a number of procedural restrictions. So those are the kind of things that one needs to be very, very careful about. The first thing, however, to work out is establishing a breach. So the biggest one, as Jonas, you probably know, is the rental arrears. That comes up quite a bit.
Yep.
And the biggest thing to think about when you're thinking about non-payment of rent, because it is one of the common ones, is by accepting rent after you've worked out a breach, are you then waiving your right to forfeit? And this becomes a very tricky area, because what then happens is if you waive your right to forfeit a lease, you then can't act on the forfeiture. So I'm going to give you some scenarios, and I want you to tell me if you think there has been an act of waiver. So is there an act of waiver if a landlord's agent takes rent even though the agent has been told not to? What do you think?
Oh, sorry, I've launched a poll. So we've launched a poll looking at the different types of breach that there might be. So thank you for everyone for filling those in. So those options are the landlord knows of the breach, and the landlord continues to demand or accept rent. The landlord accepts rent the agent accepts rent even instructed not to. The bank accepts payment unless it's repaid ASAP, or any of the above.
So in those circumstances, where would you think there has been an act of waiver? So the bank accepting the money, knowing it shouldn't, and the agent accepting money in a situation where it knows it shouldn't.
So we've had nearly 60% voted. I'll just leave that poll open for a few more seconds.
Lovely.
So we have 17% saying that the landlord knows of the breach but treats the lease as if it was still continuing, and 58% have said any of the above. Okay, so you said 58%? Yes. So I think the majority are right on. Yeah. That's good. Close that poll.
So just looking at the slide then, if you look at to amount to a waiver, it is sufficient if the rent is accepted by the landlord's agent, even if the agent has been instructed not to receive it. So you must have that line of communication open for your agent, because if they accept it by mistake, they could have waived your right. And the same applies for banks. It has been held in the case of Pearson against Harvey 1885, for an act of waiver to have been committed by the bank accepting money when it ought not to have. The important thing here is that if a mistake has been made, a landlord can remedy the situation by quickly repaying the money back. It's not a guarantee, but I would definitely recommend you take immediate steps to go back, because it may be held that no waiver exists at that point. Of course, the safest way is to put a rent stop in place, and that would really just sort of cut out any arguments that we have here. But it is just very important that you be very, very careful when it comes down to accepting rent by mistake or otherwise, because waiver does then put you back in a very difficult situation, as you can see. And I've put some cases there for everyone to have a look at later on if they want to look further into the issues surrounding waiver. Also, just to note that acceptance of a cheque which is not presented for payment, you can argue no waiver. But again, be very, very careful just by even accepting a cheque whether that does actually constitute a waiver. Moving on, there are different types of breaches. There are once and for all breaches, and there are continuing breaches, and it is always just a good idea to know what the differences are between the two. Once and for all breaches include things like assigning or underletting, or even rent arrears. And continuing breaches include things like repairing or user covenants. So obviously with continuing breaches, they arise afresh day by day. So you can always use that to go on if you are looking to forfeit a lease. But once and for all, you've got to be very careful of the arguments I've raised about waiver, because once you've got one of those types of breaches and you waive your right, you have to wait for a while before you can do anything again. You have to wait for the breach to occur again before you can take any action. So it's just very important to know what type of breach you are looking at. And obviously, I've given you some examples in the slide about what each of those can do. Jonas is going to be talking a little bit more about CRAR later on this presentation. But I will say that the use of CRAR recognises the existence of a lease and can act as an act of waiver pursuant to a very recent case of CRAR, and I won't even attempt to pronounce the surname, but it is there and the citation is there as well. So again, just be very careful that if you're looking to forfeit a lease, that you do so, but if you're looking to do CRAR, then that's a separate thing to forfeiting a lease. You've got to treat the two separately. Otherwise, by doing CRAR, you are actually saying that the lease exists and that acts as a waiver. So be very, very careful. So the prerequisite, whether you are looking to re-enter a property or whether you're looking to get an order for possession, is to serve a Section 146 notice. And that does give the tenant the opportunity to remedy the problem. I must also just advise on this note here that please, please, please ensure that the notice that you give is completely compliant with the Law of Property Act 1925, because if it isn't, your notice can be held invalid and you have to go back to square one. You don't need a Section 146 for rent arrears, but for service charges, which are reserved as rent, you have to be careful there. You don't also need it for that either, because they are reserved as rent. Okay, so that's the case of freeholders. There are many different methods of forfeiture. We've discussed that before. There is the re-entry and there is the possession order. A lot of people have asked what would happen if you had a mixed-use property. So far we've been talking about purely commercial premises, which is fine, which is lovely, nice and easy. But what happens if you've got the typical scenario of a, say, shop on the bottom floor and a residential on the top floor, which happens all the time? Well, I will just say that the case of Pirabakar and Patel 2006 spoke a lot about this particular situation, and it said that a mixed-use property should be treated as a solely residential premises. In other words, if you're going to forfeit, then you have to treat it as if it's a residential, and you have to basically go away and get an order for possession. So always exercise a bit of caution when you're thinking about mixed-use properties, and the case, again, to reference is Pirabakar and Patel. So just going over to the next slide, which is when you're transferring matters over to the High Court. I'll let Jonas take it from here.
Thank you very much, Priya. So you've really got two options. Once you've obtained an order for possession, you have the option of instructing the county court bailiffs, or you can make an application to the county court for them to grant you permission to have it enforced in the High Court. There's a couple of pros and cons for each one. So the county court bailiffs, they are usually cheaper when it comes to the enforcement. However, they can take anywhere between 6 to 16 weeks. In our experience, especially if you are based in and around the sort of London area, or your property is at least, you're more likely looking at the sort of 12 to 16 week mark on average, depending, of course, on what time of the year. The High Court option is usually a lot faster than that. However, you will need to ask the court for permission to have the case transferred up. And the guidance that we do that under is Section 42 of the County Courts Act 1984. Now, we do advise, of course, wherever possible, that you apply for permission at the time of the actual possession order, which usually comes in quite handy when you're doing, for instance, a Section 8 process. It's a bit more tricky when it comes to Section 21, because the courts do seem to not necessarily ignore some of the additional requests. However, if you have got an order for possession and you do not have permission to transfer, it's not the end of the world. You do have the option of using a Form N244. You do have the option as well of using that without a hearing, so the court fee for that would be £100. Once you've instructed us, you will then be able to, or once you've obtained the order granting leave to transfer, you will then be able to approach a High Court enforcement officer, such as the Sheriff's Office, to apply for a writ of possession. Depending on what circumstances that you're asking us to issue the writ under, the court fee can range from £66 to £166. Usually for landlord and tenant disputes, you're typically looking at £166 in court fees. And of course, thereafter, we'd be able to conduct the eviction. Now, if in the rare event you do, for instance, have squatters that have broken into your commercial premises, you don't actually need the court's permission to have it transferred up. Automatic leave, there are provisions within the civil procedure rules to allow us to simply transfer it up without the need for you to ask for permission. And in that case, the £66 fee would apply for the High Court stage. Now, if you do, for instance, make an application using an N244, say you are a landlord, you have a tenant, they haven't paid you rent. Now, this applies, of course, whether it's commercial or residential as well. How long does it take for you to hear something back from the court from the time you submit the N244 to the time you get an order back from them? It does vary depending, obviously, on court delays, etc. But in our experience, you're typically looking at anywhere up to 28 days. Usually it takes about the 3-week mark we found, but it can, at busy times, extend to 28 days in most instances. Once we've got the actual instructions, we will make an application for a High Court writ. Typically, the turnaround that you can expect with most High Court enforcement companies is in and around the 5 to 15 working day mark. So what are the costs? You've previously heard me say that there are a couple of pros and cons. The warrant for possession, if you wanted to instruct the county court bailiffs, is £121. High Court enforcement officers, usually in and around the £300 to £800 mark, depending obviously on how long it takes to get the tenants out, etc. However, one thing you do have to bear in mind is, of course, the amount of rent you're losing out. So, for instance, while the county court bailiffs may at first glance appear to be a cheaper option, if, for instance, you are paying, or let's just say your tenant is paying you £1,500 every month, if the county court bailiffs are going to be taking 3 months, then in that instance, it would actually work out to be more cost effective, for example, to instruct the High Court enforcement officers to actually attend and carry out the eviction. What happens is, of course, one of the key elements that a lot of masters, a lot of judges had concerns about previously, which we've now been able to thankfully rectify, is they were all concerned that we would simply attend out of the blue and just get the tenant out literally without giving any kind of warning or anything like that. And that's actually not the case, because we would now give them a written notice. Usually it's about 7 working days that we give them a notice for, in and around that mark, so at least that they are aware that we will be attending. But I think I'll pass this now back to Priya.
Just as a final note on the relief from forfeiture, because I think it's just very important to understand that it is a very discretionary remedy, so a judge can make any decision he or she sees fit. It's also really, really good that I mentioned to you that it is available to the tenant and any third party with an interest in the lease. So this could be the subtenant that has a relationship with your tenant. And I must stress that as a landlord, you need to be exceptionally careful not to take any rent from your subtenant, because that could be implying another type of tenancy, which would make it very difficult for you to recover possession, because it could be argued by the subtenant that they deserve an interest in the premises because you've now accepted rent from them. So when I say put a rent stop in place, it applies to everything and everyone that's associated with the property, if you are being on the safe side of matters. It's just also really, really important to, we haven't got a lot of time today to discuss, but there is a case called Zestcrest Limited against County Hall Green Ventures Limited, which does talk a little bit more about how one should be dealing with subtenants in a situation like this. It's an important case to note down, which I can advise upon with you personally if you ask any questions at the end. So just a little bit more on the relief from forfeiture. Wide discretion, as I've mentioned. The judge can make it conditional, so he can say to the tenant, look, if you fix this or do this, then you can go back into the property. So there are times when that can happen. And in my experience, I must admit, the courts are extremely tenant friendly, and they do tend to side with the tenant. So if they can avoid granting forfeiture, then they will do so. So, you've really got to be on good, strong grounds if you're going to try and resist any application for relief, I would say. So that is my ending note on relief from forfeiture.
Thank you very much. We will now have a couple of questions for a quick learning review. So I will launch that. So what must you serve before re-entry or obtaining an order for possession? Is it a Section 8 notice, a Section 146 notice, or a Section 21 notice? Give you a few seconds to vote. Well, the excellent news, Priya, is that everyone was listening. and the vast majority have selected a Section 146 notice, which is the correct answer.
Good.
So I will close that. And our second question, is a court order required to forfeit the lease for commercial premises? So we have 82% saying no. Are they correct?
You don't need to get a court order all the time. You can just do a re-entry. But if you have got a situation where the premises is a mixed-use premises and there is a dwelling of some kind, then it is always safest to go and get a court order.
Thank you very much. So, So we will move over to Jonas now to talk about CRAR.
Hello, welcome back again. So what is CRAR? CRAR is Commercial Rent Arrears Recovery. It is a tool for commercial landlords to be able to recover specific rents that are actually owed. Now, what do I mean by that? So Commercial Rent Arrears Recovery doesn't actually allow you to recover everything that's owed to you on the lease. It actually only limits it to three things. So it limits it to the rent, to the interest, and to the VAT. Now, you might say, okay, well, what about ground rent? Can I collect that? Unfortunately not. It will only be the actual rent itself. Other things that you can't collect as part of that is, for instance, the insurance premiums, service charges, utility costs, etc. These all forms as part of something that you would just simply would not be able to use CRAR to recover the money back from. Now, this came into play quite recently. It came into force on the 6th of April, 2014. It was quite a bit of a shock to the system at that time, because if you remember before 2014, it was, you could technically have leeway to recover some of the aspects that I mentioned earlier, for instance, like the insurance premiums, etc. But fortunately, that is no longer the case. But what happens if, say, for instance, you've got an inclusive rent, i.e., what we mean by that is something that includes, for instance, the service charge or the ground rent. In that part, CRAR will only be available for the part of the rent that is reasonably attributable to possession and use of the actual premises itself. So, in effect, we would need to try and exclude some of the additional costs out of it. If, however, you did want to pursue for the full arrears, i.e. you wanted insurance premium, the rates, the ground rent, everything, your only real option to do it would be to pursue them down the court route. So you could obtain a county court judgment, you could carry out a forfeiture, for instance, if you wanted to get them out of the property, or you could start and issue bankruptcy proceedings as well. Now, there must be a written lease in place, and any contract or lease that seeks to amend or avoid the CRAR provisions will, of course, be void. CRAR, very much like the forfeiture aspects of it, we can only use that for commercial premises. So that means no residential elements attached to it. Again, very similar to the forfeiture aspect. If, say, for instance, you've been letting under a sublease, for example, or occupation as a dwelling is in breach of the lease terms. Some premises, for example, pubs or certain convenience stores, will also have residential accommodations above that as well. Now, provided that the residential part has a separate entrance and a separate lease, then CRAR can continue to recover the rent, but only limited to the actual commercial unit itself. The good news and the benefit of using CRAR is that a court order is certainly not required in this instance. So, what happens at the very start? Well, as it says pretty much on the slide, it requires at least 7 clear days notice, excluding Sundays or bank holidays, as well as Good Friday and Christmas Day, to be given to the tenant. This is called a notice of enforcement. Usually this is something that a company such as the Sheriff's Office would send out to the tenant. The one major, of course, of CRAR in the surprise element found in the distress is of course removed, so we can't just simply attend out of the blue. Notice will need to be served on the tenant. The notice doesn't have to say when we're going to be arriving, but more along the lines of the opportunity to say, look, you've got X amount of days, 7 clear working days for them to contact us and arrange payments and try and sort of come to an amenable conclusion on that. Now, CRAR can be exercised between the hours of 6 a.m. and 9 p.m. on any given day of the week. But what happens if, say, for instance, the premises is, for example, a nightclub and they don't operate between those hours, or we'd have to, for one reason or another, attend at 12 o'clock midnight? Well, the provisions of CRAR says that we can attend outside of those hours if the premises are open for trade. So what are the requirements? Well, a couple of things. The tenants must be in arrears of the rent before the notice of enforcement is given. The amount of the arrears must be certain or capable of being calculated with certainty. So what does that mean? We need to, in effect, know exactly how much is outstanding. This ties into the earlier comment that I made in regards to what happens if the rent is all bunched into one. That needs to be separated so that at least we can clearly see exactly what we're going after. Now, the net unpaid rent must equal, according to the law, at least 7 days. However, there are quite a few leases out there that say that you've got to give at least, or the tenant has to be in at least 21 days of arrears. And if that is the case, then we would recommend going by what the lease actually says. Now, the tenant must also be in arrears of the net unpaid rent if, for instance, we attend and we start taking control of the actual goods itself. So what's the process? You've got now a tenant, they haven't paid you any rent, you've instructed, say, the Sheriff's Office, and we've taken on the instructions, we've sent out the notice, and an officer is now on site ready to enforce. Now, one of the options available to our enforcement officers is taking control of the goods and selling them, of course, at an auction. That is something that we can do. We could also use something called a controlled goods agreement. Now, what this is where we leave the goods on site. However, the actual goods itself would ultimately belong to the courts themselves or to ourselves. Usually we use this option in the event that, for example, the tenant does not have sufficient goods to cover the value of the debt. However, they have agreed to setting up a payment plan. So we will use the controlled goods agreement as an option to secure the debt in the event that they default on making a payment. Now, once the controlled goods agreement is underway, the tenant is, as I said, permitted to retain custody of those goods, but they acknowledge that the enforcement agent is taking control of them and, of course, agrees to not remove, they can't dispose of them, they can't sell them on, and they certainly cannot allow a third party to do that on their behalf either. If, however, as does happen, for example, that there is a breach in the agreement, most likely cause of that is that they haven't paid their payment plan, then we've got to give at least 2 days' notice to them before an enforcement agent can re-enter. Now, the EA can enter the demise premises. Now, demise premises is typically a legal term for the premises that's mentioned on the actual lease itself. We can only enter through either an unlocked door or other normal means. Now, unfortunately, if you guys have had previously instructed us or worked with us prior to 2014, you'd have appreciated that the option of going through a window is unfortunately now no longer available to us. Now, as previously mentioned on the slides, we can attend any day of the week between 6 a.m. to 9, or of course the tenant's normal business hours if, for instance, they are a nightclub, which we've had to do on quite a few occasions. If the tenant does agree to the instalments, he'll be required to sign the controlled goods agreement, which ultimately replaced the previous terminology of walking possession agreement. Notice of the sale of goods. So in this particular instance, we assume that we've taken control of the goods and now we are looking to sell them on at a local auction. The process, very simply, is what we give 7 clear days notice, which is to be given by the enforcement agents. Of course, under the old regulations, that used to be 5 days. But we would also let them know of the date, the time, and the place where the goods will be sold. There are, of course, certain exceptions. So, for instance, if we were to attend to a convenience store and we were to take control over some perishable goods, it is entirely possible that those goods will not last for the duration of the 7 clear days, and in which case we are allowed to shorten the notice period on those. Also, notice periods can be dispensed with if we believe that there is sufficient evidence to show that the tenant is at risk of removing certain goods. That will, of course, involve us making an application to the courts and asking either a master or a district judge, whoever we attend before, for them to grant us permission to dispense with notice altogether. Now, of course, as well, if the tenant is in administration, or there will be a moratorium on instituting or continuing legal process against the tenant or the property, without, of course, the court's permission or the consent of the administrator. Now, it is entirely possible, as of course has happened previously, tenants do have a right to appeal the actual CRAR. So they can approach the courts and they can ask for an order whereby we were forced to take any further steps, unless, of course, there's a further court order in place in relation to the rent that's claimed. Now, the conclusion of it, which what you'll need to understand about CRAR, is it is simply a way for the courts to rebalance a landlord's rights and just put them back really in line with other creditors. A tenant will no doubt welcome these changes. Obviously, a landlord will certainly be concerned to some degree over the erosion of their rights, the time, cost, and delay it will have to suffer when seeking to recover rents that are agreed by the tenant in the lease. So, other methods of commercial rent. Now, of course, a landlord may choose to go down the route of obtaining a CCJ under some of the following terms. So the tenant could have left the property and they've got absolutely no assets in the property whatsoever. It could also be that the goods are located in another office or a warehouse that is owned or rented by the tenant. It could be that there is, of course, a sizable debt beyond the rent that's owed. For instance, they could have service charges, insurance, etc. But of course, as well, you can only use CRAR where there is a lease in place. So if you have, for example, a license agreement, That would be an option where a county court judgment would also be required. Other examples of that also include if it's a mixed-use premise, like for instance it's a commercial and residential premises as well, or where the landlord needs to repossess the property via a court order and also wishes to recover rent arrears, which would be similar to, for instance, a Section 8 process. Priya, did you have anything else to add on that at all?
Just to add that there are, other methods of getting the job done apart from getting a CCJ. Landlords, you do have the option of commencing bankruptcy proceedings against somebody if they are in arrears of rent, for example. That would be a whole entirely different talk and presentation that we don't need to give you. But of course, if you are looking to serve a statutory demand on an individual, the debt would have to be at least £5,000 in order for us to get that off the ground. So again, there are different options, and it is about seeking that legal advice, but bankruptcy is also one of them. So I hope that helps.
Thank you very much. We'll now have our second learning review. Just a reminder that please, we're going to have a question and answer section after this, so please just type in any of your questions and we'll get through as many as we can at the end. So the first learning review is, what is the minimum amount of unpaid rent that must be due before CRAR can take place? So is that 7 days, 14 days or 30 days? So we have 82% saying 7 days.
Yep.
That would be the correct answer. Excellent. And our next question is, how much notice must be given to a commercial tenant under CRAR? So is that 7 clear days, 14 days, or no notice needs to be given? Give you a few more seconds to answer that. So we have 93% saying 7 clear days.
Yep.
Yep. I'll close that now. And then our final question is, when can CRAR be undertaken? And the options are any day of the week between 6 AM and 9 PM, normal business trading hours, or all of the above. So between 6 AM and 9 PM took an early lead, but that has been overtaken now by 74% of people saying all of the above.
Yep, that's right.
That's correct. Excellent. So thank you. We will now move on to our questions. So we've had some questions come in. We've had some for Priya. So in terms of returning rent arrears to prevent waiver, Priya, someone has asked, how quickly is quickly?
I think that's a fantastic question. I will say that as far as I'm aware, this hasn't been defined in strict terms in the law. So I wouldn't be able to say what is, how quickly is quickly, essentially. What I will say, however, is I do think it's context dependent. So it does depend on the specific facts of the case and how quickly one was expected to act in a situation like that. So in certain scenarios, a couple of days might be deemed as quick enough. In other scenarios, it may be too slow. It does, I would say, depends on it's context dependent, as I'm not aware that it has been defined in law as such.
Thank you very much. And then a question is, why is the Section 146 notice not considered as a waiver, as it is in effect a demand for payment?
I think insofar as serving a 146 notice for rental arrears, you, as I mentioned before, you don't actually need to serve a Section 146 for rental arrears. And I think because there is an argument to say that it is in effect a demand for payment and therefore an act of waiver, I think that's probably why the law has created an exception there in terms of not serving a Section 146 for rental arrears. And I also want to point out, this is another very, very good question. I've seen a lot of landlords do this quite regularly actually. It's where they accept rent from the tenant with an intention to forfeit the lease, but then what they've said in a cover letter or an email is it's without prejudice to my right to forfeit. Well, I'm just going to draw your attention to the case of Central Estates, Belgravia Limited, against Woolgar, which is a 1972 case, which again talks about if a landlord knowing of a tenant's breach of covenant demands rent, he cannot avoid the consequences, even by an express reservation of his rights. So even if you put in those lovely two words, without prejudice, it is dangerous business and it doesn't completely get you off the hook. It is considered an act of waiver. So again, it's just when it comes to rental arrears, it's about being, I would say, quite clear cut with taking action or not taking action with forfeiture.
Thank you. Okay. A question here. If you obtain a judgment for rent arrears in the county court and instruct an HCEO to transfer it to the High Court and enforce it, who pays the cost?
Sorry, say that again, sorry?
So if you obtain judgment for rent arrears in the county court and instruct an HCEO to transfer it to the High Court and then enforce it, who pays the cost?
In the first instance, it would actually be the landlord themselves. Usually the cost for actual enforcement is levied against the actual landlord in the first instance. Should you wish to try and recover the rent, you'd need to make a further application to the court, but in all fairness, over the last 7 or so odd years I've been doing this job, I haven't seen a single one actually be granted. So I think you'll be hard pressed to find a judge that will actually agree for the tenant to bear the cost of the evictions.
Thank you. And we have a question. What is the name of the case regarding mixed-use properties?
Yes, the case, which may be the way I'm saying it, I may be saying it wrong, but I'm going to go with Pirabakaran against Patel 2006. I'll say that again, bit of a mouthful. Pirabakaran against Patel 2006.
Thank you. And then another question we have, they're coming in thick and fast. If the lease says the landlord may sell goods left on premises if the tenant does not remove them within a certain time, could the landlord then sell them without court permission?
The answer is yes. However, I believe that they will need to be served with something called a tort notice in the first instance. Once the tort notice, of course, has elapsed, then the landlord would have the right to sell them on to recover the rent.
Correct.
Yep. Okay. If I have judgments against squatters in a commercial property, do I need the county court's consent to transfer to the High Court?
Good question. No. So long as you've put it through under trespasser proceedings, so on the claim form you've ticked the trespass box, no, you don't need to ask the courts for permission. You just simply instruct the enforcement officers and they can then carry out the transfer on your behalf.
So this is a forfeiture question here. If you have it in the contract to enter the property if the tenant is present or not, in the event of a forfeiture lease, can this be done?
Say that question again.
So that is, if you have it in the contract to enter the property if the tenant is present or not, in the event of forfeiture of the lease, can this be done?
Well, from the way I understand that question, you can re-enter as long as it's peaceful and there is an express right in the lease. So it sounds about right.
Yeah, absolutely.
Question, do I need to serve a Section 146 notice before forfeiture of lease?
Thank you. You do need to serve a Section 146 notice, whether you are re-entering or whether you're obtaining an order for possession. So either which way, you need to serve a Section 146. The only exception to that is if, of course, if you're doing rental arrears, then you don't need to do the 146.
Okay. Does it amount to a waiver when accepting rent whilst at court prior to a possession order being granted?
I would say at court, did you say?
Yes. So does it amount to a waiver when accepting rent whilst at court prior to the possession order being granted?
I would need to have a good think about that and come back to you before coming up with a knee-jerk reaction answer. I have an idea, but...
Well, one thing we always do after our webinars is we write up the questions and put answers to that. So we will cover that in an article in the newsletter when we cover that through.
Good question, though.
Okay. Can we apply for CRAR if the sublease has expired and a new one has not been signed yet, but the subtenant continues to pay rent after the old sublease has expired?
Do you know what? This is a very complicated question because the answer to that is really going to be dependent on the circumstances of the lease. For instance, is the lease excluded from the Landlord and Tenants Act? And depending on the answer to that will certainly form the basis of my question. Assuming that everything is in order and that the leases can be viewed as simply rolling over, then yes, in theory, we could possibly attend and sort of continue as if the lease is currently in place. But it is a very difficult question, and we would probably need more information to answer that as accurately as we possibly can.
Right. Are there any more questions to come in? We've had quite a few. Yes, there are. If you move a tenant's good off the property after a controlled goods agreement, and the tenant was unwilling to prove ownership or pay rent, can you then argue that since you have new locks and vacant possession, forfeiture has occurred and the lease has ended?
I would say that's another question that we need to give some
careful
consideration to. I wouldn't be comfortable giving an off-the-cuff comment on that.
Okay. Another question, what is the name of the 1972 case that deals with the landlord accepting rent without prejudice to the right to forfeit?
Yes, I do apologise. I may have said that rather quickly. It is Central Estate, brackets Belgravia, Limited against Woolgar, which is a 1972 case. If you wanted the citation, we can always send that to you individually, but that should be good for now.
Are there any more questions to come in? Okay, I think the slide said that only a certificated enforcement agent could forfeit by re-entry. Is that correct, or is it just one option?
So, very good question. I believe that the actual methods of forfeiture would only be able to get a certificated enforcement agent to carry that out.
Okay. Are there any more questions coming in? Yes, there's another one here. Oh, thank you very much. So someone has asked if we can send a list of the cases referred to today. Yes, we will be sending out all of the slides at the end, and the cases referenced are all in the slides. We will get that.
I'm glad everyone likes the cases. Took a while to source.
And then another question here is, this is about Section 146. Do we need to indicate how long the Section 146 should be valid for, or shall we refrain from inserting a date?
You do have to have, it's all very prescribed, the Section 146. Let's have a quick, I do believe it's about, you have to give them a reasonable period. And I would say that that's normally in my world is about 14 days, but it depends on the type of breach you're talking about. Some things you can't sort out in 14 days. So I do think you need to put in a reasonable period, and I think that can be tweaked, but you do need to give some time allowance.
Excellent. We've got time for a couple more questions. Are there any more questions to come through? No more questions? Okay, well, I think that we'll end the webinar there. And thank you very much to our presenters today.
Thank you.
Thank you.
And as I said, we will be launching a survey at the end when this closes. If you could fill that in, we'd very much appreciate that. And we will be sending you the copy of the slides, a link to the recording from today's webinar, and your CPD certificate tomorrow. Thank you very much.
Thank you.
Thank you.